viewers, welcome to my channel. I'm Hasham. So now I'm going to start a new topic in business law. So far in the last videos I have completed the Indian Contract Act 1872 and Sale of Goods Act 1930. Now I'm going to start Companies Act 2013. So this is also a part of business law. So in this video and the coming video, I'm going to discuss the provisions regarding Companies Act 2013. In this video, I'm going to start with the topic management of companies and meetings. So in this video and the coming video, our topic will be management of companies and meetings of the companies. Actually, the company is managed by a group of members, board of directors. These board of directors are the body which is appointed by the members of the company. Already we know company is an artificial person created by law. It does not have a physical existence. So the company will perform the functions through directors. The company will perform the functions through directors. So in this video I am going to explain you about who are directors. Who are definition of directors, then qualification, disqualification of directors, duties and liabilities of directors, appointment and removal of directors, position of directors, then loans given to directors or remuneration of directors, managing director, then corporate social responsibility CSR and corporate governance. These are the topics I am going to take up in management of companies. Then meetings. What is the meaning of the term meeting and what are the requisite for conducting the meetings? Requisite for conducting the meetings and the different issues with the meetings like notice of meeting, proxy, agenda, quorum and resolutions. Then we have minutes and the different types of meetings. A number of types of meetings will be conducted by the company. Example, members meeting, board meeting, board of directors meeting, then annual general meeting, statutory meeting, extraordinary meeting, different types of meetings, kinds of meetings are there. So this is the total concern in this video and the coming videos. But in this video our lecture will be confined only to directors, qualification and disqualification. That's it in this video. First of all, a company is an artificial person. That means it does not have a physical existence. It does not have physical existence. It cannot perform its own functions. It cannot take its own decisions. So company's decisions will be taken by directors. So according to section 2, subsection 34 of the Companies Act 2013, it says the term director is defined as a person who is appointed to the board of the company. Board means board of directors. A person who is appointed to the board of the company is called a director. This is the definition given by section 2, subsection 34. Subsection 34. The board of director is defined as a person who is appointed to the board of the company. So this is the definition. A director is a person who is appointed to perform the duties and functions of the company in accordance with the provisions of the Companies Act. All the companies are governed by the Companies Act 2013. So this Companies Act 2013 has given a number of provisions how to run the company, how the decision, different types of decisions will be taken. So a board of directors, the director have to perform all the duties and functions of the companies according to the provisions of the Companies Act 2013. Now, the position of directors. The person who regulate, direct, conduct and manage the affairs of the company. That means the company's functions, duties will be performed by the directors. Directors are the drivers of the company. They will take all important decisions of the company. So their position is very, very important. Now the directors are the brains of the company. Just the brain, the function of the brain is it will direct all the body parts. The brain is the main main part of the body, because through mains only all the functions will be performed. Same, directors are the brain of the company. All the functions will be performed through the directions of the directors. Then they play crucial role in the company. The company's success or failure depend on the decisions taken by the directors. So directors play a very important role in a company. Now only individual can be directors. To become a director, only individuals are eligible. A corporate body, an association or a partnership cannot become a director. Only individual person can become a director. Directors take decisions regarding the management of the company in board meeting. Suppose individually they are called directors. But normally a company will not have only one director. It may have more than one directors. So combined jointly, all the directors constitute board of directors. So all the important decisions of the company will be taken by the board of directors. So all the decisions will be taken in board meeting. So this shows the meaning of the term director. In examination, a question may be asked, define or explain the directors of a company. So this lecture, whatever I explained, if you write, you can be able to get the good marks. First of all, you have to quote the section. Section 2, subsection 34 of the Companies Act 2013 explains, a director is defined as a person who is appointed to the board of the company. A director will perform all the duties and functions of a company according to the provisions of the Companies Act. So he occupies a very important position because the decisions of the company will be taken by directors. Now, number of directors. The next topic is number of directors. The Companies Act 2013 has fixed the number of directors in a company. So minimum, maximum. First of all, minimum number of directors. For minimum number of directors for public company, the minimum number of directors are 3. For a private limited company, the minimum directors are 2. I am not going to explain here what is a public company, what is a private company, what are the differences. It is not here in this discussion. Here you have to remember how many directors, minimum number of directors in public company are 3 and private company 2. Suppose a new type of company has been started recently, that is one-man company, one-person company, a one-person company. So normally this one-person company is a private company only, because public company will not have one member. So this one-member company normally is a private company. The minimum number of directors for a one-member company is 1. Minimum number of directors in a one-member company is 1. Now maximum number of directors. Minimum we have seen. Now maximum number of directors, a company may have maximum 15 directors. Maximum 15 directors. But a company is eligible to have more than 15 directors also, provided a special resolution should be passed by the company. A company should pass a special resolution to have more than 15 directors. If the company pass a special resolution, then the company may have more than 15. But without that special resolution, maximum number of directors are 15. 15. That's all. So I have explained you the who is a director, definition of director, and number of directors in a company. Now I am going to explain you about qualification and disqualification of a director. What are the qualifications of a director? The Companies Act has not fixed any specific qualification, academic qualification. Anybody can become the director. But the position of director is very, very crucial. Anybody cannot become a director of a company because this position is very important. The survival of the company, the success of the company depends on the caliber of the director. If the director is efficient, capable, then the company can be able to attain the objectives. Otherwise, the company will collapse. The position of director is very, very important. That's why not directly but indirectly some requirement has been given by the Companies Act. The Companies Act has not given any academic qualification that director should be a graduate or postgraduate or a professional. It has not given. So here I have given a director is a highly important person in the corporate affairs. So he must be very qualified. He must be qualified. Qualified in the sense he must have the knowledge. He must have the experience. He must be sharp. Then only he can be able to justify his position. But unfortunately, Companies Act does not lay down any academic qualification for directorship. The Companies Act has not specified what is the academic qualification for director. And it is logical because the right to trade is fundamental for everyone. Anybody can do the trade. It is not necessary that only those people who are having commerce, accounts, background, they can run the business. No, business can be run by any person from any field, from any faculty. A person can do the business. So that's why Companies Act says we cannot restrict the qualification of director. Anybody can become the director because everybody has a fundamental right to do the trade, to do the business. But the Companies Act, in order to weed out the dishonest person from running companies, laid out many requirements. Directly, the company has not given the qualification. But indirectly, in order to weed out the dishonest people to become the director, the dishonest people should not become the director. That's why some requirement has been given by the Companies Act 2013. So this requirement itself we can say qualification. The requirements given by the Companies Act, that itself will be the qualification. So what are the requirements? A director must be a person of sound mind. That is compulsory because only a sound mind person can take prudent decisions. So a director must be a prudent person. That means he must have a sound mind. Secondly, a director must hold share qualification if AOA provides. AOA stands for Articles of Association. Every company will have the Articles of Association regarding the terms and conditions, regarding the functioning of the business. The functioning of the business, the terms and conditions will be written in the Articles of Association. So normally, a company will write a clause, a content in the Articles of Association that any person who wants to become the director must hold so many shares, qualification shares. Only if a member holds so many qualification shares, he can become the director. He can become the director. So this requirement will be given in the Articles of Association. So any director, any person who wants to become the director must hold the qualification shares which is specified in the Articles of Association of the company. A director must be an individual. One more requirement. Director must be individual. No company, no association, no partnership can become the director. A director must be an individual only. That is a qualification requirement. Next, a director should be a solvent person. Solvent person means a person whose assets are more than his liabilities. A person whose assets are more than his liability is called a solvent person. So this director should not be an insolvent. He should be a solvent person. Last one, a director should not be convicted by the court for any offense. The person cannot be elected as a director if he is convicted by a court regarding some offense. Suppose a person has done some crime, some illegal activity. The court has debarred him from becoming a director. In that case, the person will not. The person will not. So simply, a convict person, a convict on which some imprisonment is made for his act, that person cannot become a director of a company. So I have explained you about the qualifications of a director. Now, disqualification of director. When a person is disqualified, so section 164 of the Companies Act 2013 has mentioned the disqualification as follows. First one, A person should not be capable of being appointed director of a company if he or she, when a person cannot become a director, incapable of becoming a director. Conditions: first, of unsound mind. First condition, if a person, whether it is male or female, if unsound mind is there, that person cannot become a director. Disqualification. Second, an undischarged insolvent. A person who is declared insolvent by the court. A court has already adjudged a person as insolvent person. Simple words, an insolvent person cannot become a director. Third one, has applied to be adjudicated as insolvent and the application is pending. A person is not adjudged insolvent, but he has applied to the court to declare him as insolvent and the case is pending. And the case is pending before the court of law. Not completely, declared that he is an insolvent, but the court case is pending. That person is also not eligible to become director. Has been convicted by a court of any offence involving moral turpitude and sent to imprisonment for not less than 6 months. Suppose a person is convicted for an offence of moral turpitude and he is sent to imprisonment not less than 6 months. If he is sent to imprisonment for less than 6 months, he may be eligible. But if the court has sent the person for imprisonment for more than 6 months, the person is not eligible to become a director. Disqualified. Has not paid any call in respect of shares held by him. Call money. When the company has made a call to the shareholders, it is a responsibility, it's the obligation of the shareholder to pay the call money. Suppose if a person has defaulted in making the payment call money to the company for more than 6 months. For more than 6 months. For example, Mr. X is a shareholder, already holding so many shares. The company has made a call, unpaid call. The company has called the money, but Mr. X has not paid the call. Defaulted in making the payment, call money, for more than 6 months. Then again, he is not eligible to become the director of the company. An order disqualifying him from appointment as director has been passed by the court. The court has been given wide powers on different, basis. On different basis, on equitable basis, the court may adjudge any person to be disqualified from becoming a director of the company. On some equitable basis. So on some equitable basis, justifiable basis, the court may declare any person that this person cannot be appointed as director of a company. So these are the cases where a person cannot become a director of a company. Disqualified. First one, unsound mind. Second, adjudged as insolvent, declared by the court as insolvent. Third one, person has applied to the court to declare him as insolvent, but the case is pending. The court has not yet adjudged him as insolvent. Next one, has applied to be adjudged. Then has been convicted. If a person is convicted for any offence of moral turpitude and the court has sent him to imprisonment for more than 6 months, the person will not be eligible. He has not paid the call money for more than 6 months, or any other ground on which the court declared that this person cannot be appointed as the director. Next one is, such person is already a director of a public company which. It is not necessary that a person can be a director of only one company. A person can be a director of more than one companies. More than one company. For example, Mr. X is already a director of ABC company, already a director of CDE company, already a director of PQR company. So different companies are there. So a person can be a director in multiple companies. But in that case, what will happen? Now see here. Such person is already a director of a public company which has not filed the annual accounts and annual returns for any continuous 3 years, commencing on or after 1/4/1999. Example, Mr. X wants to become a director in PQR company. Already he is a director in ABC company. Mr. X already he is a director in ABC company. Now he wants to become a director of another company, PQR. The law says he cannot become the director of PQR company if the present directorship of ABC company, the ABC company has failed to make the annual returns, to make the annual accounts for 3 or more than 3 consecutive years after 1/4/1999. Suppose ABC company. In ABC company, Mr. X is a director. Since last 5 years, this ABC company has not prepared the annual accounts, has not prepared the annual returns. Then Mr. X cannot become the director of PQR company. The law will not allow him to become the director of PQR because he has defaulted in the old company. In the other company, he has defaulted. The company has not prepared the annual accounts. The company has not prepared the annual returns. So, has not filed the annual accounts and annual returns for any 3 consecutive financial years commencing on or after 1/4/1999. First case. Or has failed to pay its deposits or interest thereon on due date, or redeem its debentures on due date, or pay dividend, and such failures continues for 1 year or more. In the last company, in the other company has failed to repay the deposits. Same example, Mr. X. Presently, he is a director of ABC company. Now he is proposing to become a director of PQR company. The law says, first of all, we'll check whether you are eligible to become the director of PQR company or not. So how to check the eligibility? Presently, where you are the director? ABC company. Is the ABC company repaying the deposits? Is the ABC company paying the interest on deposits? Is the ABC company redeeming the debentures, money, and paying the dividend? For 1 or more years, if it is not paying the dividend, for 1 or more years, if the company is not paying dividend, not paying interest, not redeeming the debentures, then Mr. X cannot become the director of PQR company. Now, provided that such person shall not be eligible to be appointed as director, any other public company for a period of 5 years from the date on which such public company in which he is a director failed its annual accounts and annual returns, or has failed to repay its deposits, interest, or redeem its debenture on the due date. From the 5 years, the previous company in which there is a default, ABC company is defaulted in preparing the annual returns, in preparing the annual accounts, and defaulted in paying the deposit money, in repaying the interest money, or redeeming the debentures, paying the dividend. If the other company is defaulted for 5 years, after 5 years, he can become the director of any other company. So this shows the disqualification of director. So in this video, I have explained you about the definition of director and number of directors in a company, then qualification and disqualification of a director. So the same discussion, regarding this director, what are the provisions regarding appointment, removal, and position of directors? All these things we'll discuss in the coming video.